We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article E, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the 2nd class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year, so that 1/3 may be chosen every 2nd year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained to the age of 30 years, and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members, in such manner and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. Each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy, and the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither house, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. Section 6. The senators and representatives shall receive a compensation for their services, to be ascertained by law, and paid out of the Treasury of the United States. They shall in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments, as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections to that house in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that house shall agree to pass the bill, it shall be sent, together with the objections, to the other house, by which it shall likewise be reconsidered, and if approved by 2/3 of that house, it shall become a law. But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States, to borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states, and with the Indian tribes, to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures, to provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads, to promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, to constitute tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas, and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers, and the authority of training the militia according to the discipline prescribed by Congress, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by cession of particular states, and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid, unless in proportion to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the treasury but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver, coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority, and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President, and if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. But in choosing the President, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. The Congress may determine the time of choosing the electors, and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States, at the time of the adoption of this Constitution, shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. In case of the removal of the President from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed, or a President shall be elected. The President shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States, or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation: I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will to the best of my ability preserve, protect, and defend the Constitution of the United States. Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states. When called into the actual service of the United States, he may require the opinion, in writing, of the principal officer in each of the executive departments, upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3. He shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Section 2. The judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state, claiming lands under grants of different states, and between a state or the citizens thereof, and foreign states, citizens or subjects, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Section 3. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states, without the consent of the legislatures of the states concerned, as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Section 4. The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature, or of the executive, when the legislature cannot be convened, against domestic violence. Article VV. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes, as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state, to the contrary notwithstanding, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. The word, "the," being interlined between the 7th and 8th lines of the first page. The word 30 being partly written on an erisor in the 15th line of the first page. The words is tried being interlined between the 32nd and 33rd lines of the first page, and the word "the" being interlined between the 43rd and 44th lines of the second page. Attest William Jackson, Secretary done in Convention, by the unanimous consent of the states, present the 17th day of September, in the year of our Lord, 1787, and of the independence of the United States of America, the 12th, in witness whereof we have hereunto subscribed our names. G. Washington, President and Deputy from Virginia. Amendment 1. Passed by Congress, September 25th, 1789. Ratified December 15th, 1791. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Amendment 2 passed by Congress, September 25th, 1789. Ratified December 15th, 1791. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 30 passed by Congress, September 25th, 1789. Ratified December 15th, 1791. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Amendment 4 passed by Congress, September 25th, 1789. Ratified December 15th, 1791. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Amendment V passed by Congress, September 25, 1789, ratified December 15, 1791. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 6, passed by Congress, September 25, 1789, ratified December 15, 1791. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7, passed by Congress, September 25, 1789, ratified December 15, 1791. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Amendment 8, passed by Congress, September 25, 1789, ratified December 15, 1791. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Amendment 9, passed by Congress, September 25, 1789, ratified December 15, 1791. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 9, passed by Congress, September 25, 1789, ratified December 15, 1791, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Amendment 11, passed by Congress, March 4, 1794, ratified February 7, 1795. Note Article 3, Section 2 of the Constitution was modified by Amendment 11. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. Amendment 12, passed by Congress December 9, 1803, ratified June 15, 1804. Note, a portion of Article 2, Section 1 of the Constitution was superseded by the 12th Amendment. The electors shall meet in their respective states and vote by ballot for President and Vice President, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as President, and in distinct ballots the person voted for as Vice President, and they shall make distinct lists of all persons voted for as President, and they shall make distinct lists of all persons voted for as President, and they shall make distinct lists of all persons voted for as President, and they shall make distinct lists of all persons voted for as President, and they shall make distinct lists of all persons voted for as President, and they shall make distinct lists of all persons voted for as president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers, not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in case of the death or other constitutional disability of the president. Asterisk. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Asterisk, superseded by Section 3 of the 20th Amendment. Amendment 13, passed by Congress January 31st, 1865. Ratified December 6th, 1865. Note: a portion of Article 4, Section 2 of the Constitution was superseded by the 13th Amendment. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States, and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may by a vote of 2/3 of each House remove such disability. Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. Asterisk, changed by Section 1 of the 26th Amendment. Amendment 15, passed by Congress, February 26, 1869, ratified February 3, 1870. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Amendment 16 passed by Congress July 2, 1909, ratified February 3, 1913. Note, Article 1, Section 9 of the Constitution was modified by Amendment 16. The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Amendment 17 passed by Congress May 13, 1912, ratified April 8, 1913. Note, Article 1, Section 3 of the Constitution was modified by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election, as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. Amendment 18, passed by Congress December 18, 1917, ratified January 16, 1919, repealed by Amendment 21, Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territory subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Amendment 19 passed by Congress June 4th, 1919, ratified August 18th, 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. Amendment Tecte, passed by Congress March 2nd, 1932, ratified January 23rd, 1933. Note Article 1, Section 4 of the Constitution was modified by Section 2 of this amendment. In addition, a portion of the 12th Amendment was superseded by Section 3. Section 1. The terms of the President and the Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3 days day of January, of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3 days day of January, unless they shall by law appoint a different day. Section 3. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified, and the Congress may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. Section 4. The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a President, whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a Vice President, whenever the right of choice shall have devolved upon them. Section 5. Sections 1 and 2 shall take effect on the 15th day of October, following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Amendment 21, passed by Congress February 20th, 1933, ratified December 5th, 1933. Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors, in violation of the laws thereof, is hereby prohibited. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Amendment 22, passed by Congress March 21st, 1947, ratified February 27th, 1951, Section 1. No person shall be elected to the office of the President more than twice, and no person who has held the office of President or acted as President for more than 2 years of a term to which some other person was elected President shall be elected to the office of the President more than once. But this article shall not apply to any person holding the office of President when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term within which this article becomes operative from holding the office of President or acting as President during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress. Amendment 3 passed by Congress June 16, 1960. Ratified March 29, 1961. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of President and Vice President equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered, for the purposes of the election of President and Vice President, to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment up to 4 Pev. Passed by Congress August 27, 1962. Ratified January 23, 1964. Section 1. The right of citizens of the United States to vote in any primary or other election for President or Vice President, for electors for President or Vice President, or for Senator or Representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President, who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office, unless the Vice President and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress, within 21 days after receipt of the latter written declaration, or if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. Amendment Death Aim 1E5 passed by Congress March 23, 1971. Ratified July 1, 1971. Note: Amendment 14, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment. Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. Amendment Dec. 77, originally proposed September 25, 1789, ratified May 7, 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. The 27 amendments to the United States Constitution. With the Constitution, the founding generation created the greatest charter of freedom in the history of the world. However, the founders also left future generations a procedure for continuing to improve it, the Article 5 amendment process. Over time, the American people have used this amendment process to transform the Constitution by adding a Bill of Rights, abolishing slavery, promising freedom and equality, and extending the right to vote to women and African Americans. All told, we have ratified 27 constitutional amendments across American history. We can divide these amendments into 4 different periods of constitutional reform. The founding era, 1791 to 1804, gave us our first 12 amendments, including the Bill of Rights. The Reconstruction era, 1865 to 1870, gave us 3 transformational amendments that many scholars refer to as our nation's second founding. These are the 13th, 14th, and 15th Amendments. Notice the 60-year gap between the 12th and 13th Amendments, a reminder that constitutional amendments often come in waves. This progressive era, 1913 to 1920, gave us the 16th through the 19th Amendments. Again, notice the 40-plus year gap between the 15th and 16th Amendments. This progressive era, 1933 to 1992, added the remaining 8 amendments, little by little, between 1933 and 1992. And now it's been over 3 decades since our last constitutional amendment. The founding generation used the new Constitution's amendment power almost immediately, adding 12 amendments in less than 2 decades. The Bill of Rights, the first 10 amendments, authored primarily by James Madison, were proposed by the first Congress and ratified shortly thereafter. Of course, this is our Bill of Rights. These amendments protect some of our most cherished liberties, including free speech, a free press, religious freedom, and the right to a jury trial, among many others. The Bill of Rights was drafted in response to the concerns of the Anti-Federalists, the group of Americans who opposed the Constitution, who demanded key liberties be protected against too large a national government. These amendments originally applied only to the national government, not the states. The 14th Amendment would later extend many of these rights to protect us against state abuses. Scholars call this process incorporation. The First Amendment. We begin with the First Amendment, which is its own bundle of rights, including rights associated with religion, speech, press, assembly, and petition. Religion? The First Amendment protects religious liberty in two ways. First, it guards against government establishment of religion. Second, it protects the free exercise of religion. Together, these constitutional promises are at the core of our freedom of conscience, the right to freely believe, or not, as we wish. Speech, press, generally speaking, the government may not jail, fine, or punish people or organizations based on what they say or write, and the court protects speech unless it is directed to and likely to cause immediate lawless action. Today, the Supreme Court protects free speech rights more strongly than at any time in our nation's history, and American free speech protections are among the strongest in the world. At the same time, there are certain contexts when the government has more leeway to regulate speech. For instance, with low-value speech like defamation, or when speakers, like public school students, have a special relationship with the government. Assembly petition. Throughout American history, minorities and those without power have used assembly and petition rights to find voice and power in their quest for greater freedom and equality. The list includes African Americans, women, unpopular political groups, for example, and Jury gay, abolitionists in the early 1800s, and many others. The Second Amendment for the founding generation. The Second Amendment went to early concerns about standing armies and the value of rooting the communities and nation's safety in a well-regulated, citizen-led, and filled militia. Consistent with the Supreme Court's recent decisions in Heller and McDonald, the Second Amendment grants an individual the right to keep and bear arms, including personal handguns in the home, for self-defense. The Supreme Court extended these protections outside of the home in New York State Rifle and Pistol Association v. Bruin. But the court has left many Second Amendment issues open for future cases. This includes issues like assault weapon bans and red flag laws. The Third Amendment. The Third Amendment protects us from being forced by the government to house soldiers in our homes in times of peace. This grows out of the American colonial experience of the British Quartering Act of 1774. The founding generation saw these British abuses as tyrannical and viewed this act as invading the sanctity of private property and the home. The Fourth Amendment. The Fourth Amendment can be broken down into a few parts. Which things are protected? The government needs particularized suspicion, a reason that's specific to each suspect, before it can get a warrant. Broadly speaking, our Constitution says that the police should only be able to invade a person's rights to privacy, property, or liberty if they have a specific reason to think that the suspect has done something wrong. The Fifth Amendment. The Fifth Amendment, Takings Clause, is connected to the founding generation's commitment to property rights. It protects private property from being taken by the government for public use without just compensation. It means that if the government wants to take your property, it has to be for public use, and the government has to pay you a fair price for it. The Fifth Amendment also grants certain rights to criminal defendants, the right to remain silent against self-incrimination. For example, you have the right to remain silent, and I plead the Fifth. Double jeopardy, a right to a grand jury for capital crimes, and a right to the due process of law, a fair process, before the government may deprive anyone of life, liberty, or property. The Sixth Amendment. The Sixth Amendment grants even more rights to criminal defendants, including the right to a jury trial in criminal cases, right to counsel, lawyer right to counsel, so to a lawyer, a speedy and public trial, an impartial jury, be informed of what crime the government is charging against you, and cross-examine witnesses against you in person, known as the Confrontation Clause, and compulsory process for witnesses, basically the power of the court to order someone to appear in court as a witness for the defense, and crass of compulsory process, 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 and crass of compulsory process. Subpoena power. The Seventh Amendment. The Seventh Amendment protects the right to a jury trial in civil non-criminal cases. This responded to a key concern of the Anti-Federalists that the original Constitution in Article 3 only protected the right to trial by jury, considered a fundamental liberty in criminal cases, and many states did not protect them for civil cases. The Eighth Amendment. The Eighth Amendment protects the right against cruel and unusual punishment, excessive bail, and excessive fines. It's rooted in the English Bill of Rights and the Virginia Declaration of Rights. It reflected concerns of anti-federalists like Patrick Henry, who worried that a new and powerful national government would simply invent new crimes to oppress the American people. The Ninth Amendment. The Ninth Amendment is interpreted by many scholars to write certain natural rights into the Constitution, a cautionary note that the American people have even more rights than are written clearly into the Constitution itself. It reflected widespread concerns that the Bill of Rights might not list all of the most important rights, liberties, and might not limit the national government's power enough. The Tenth Amendment. The Tenth Amendment reflects the Constitution's commitment to federalism, the traditional balance of power between the national government and the states. It was meant to protect the reserved powers of the states, meaning the powers that the states held before the Constitution was ratified, the police power, while also reminding those in government that power originates with the American people, popular sovereignty. So that's the Bill of Rights. The 11th Amendment. 4 years after the ratification of the Bill of Rights, the American people ratified a new amendment, the 11th Amendment, 1795. This amendment bans the national courts from hearing certain lawsuits against states. Scholars often refer to this as protecting a state's sovereign immunity. Under the original Constitution, the national courts were granted power under Article 3 to decide cases between a state and citizens of another state or nation. Anti-federalists feared that this would allow ordinary people to sue a state in a national court. Some key Federalists who supported the Constitution argued that the Constitution wouldn't allow national courts to hear cases against states unless the states themselves gave their approval. However, other Federalists disagreed, arguing that the Constitution allowed for lawsuits against states as a way to hold them accountable for abuses against ordinary people. In 1793, the Supreme Court decided a case called Chisholm v. in Georgia, which involved a citizen of South Carolina suing the state of Georgia. Georgia argued that a national court didn't have the power to hear this lawsuit, but in a 4-1 vote, the Supreme Court sided with Chisholm, arguing that national courts did have the power to hear this case. The Anti-Federalists' fears came true. The Chisholm decision proved quite controversial, and the 11th Amendment was proposed and ratified shortly thereafter as a way of reversing the Supreme Court's decision. It was ratified in less than a year. The 12th Amendment following the election of 1800. The American people ratified the 12th Amendment, altering the Electoral College and addressing problems that emerged in some of our nation's earliest presidential elections. Under the original Constitution, electors cast ballots not for one presidential candidate, but for two of them, with the second-place finisher becoming the vice president. The framers didn't expect that there would be national parties that nominated candidates and offered their own tickets for president and vice president. However, political parties quickly emerged, and the strange two-vote system led almost immediately to a serious political crisis. In 1796, Vice President Adams faced off against former Secretary of State Thomas Jefferson. Even as early as 1796, political parties had already begun to emerge, and Adams, a Federalist, and Jefferson, a Democratic Republican, were already associated with opposing political parties. In the end, Adams won 71 electoral votes to Thomas Jefferson's 69, but the electors' second votes were scattered. As a result, none of the Federalist candidates for vice president received more total votes than Jefferson, so he became Adams, his opponent's, vice president. Adams and Jefferson squared off again in the election of 1800, but this time Jefferson defeated Adams by a vote of 73 to 65 in the Electoral College. This election marked the arrival of the two-party system and was a bitterly contested election. Even as Jefferson outpaced Adams in the Electoral College, he actually tied his fellow party member and nominal running mate, Aaron Burr, 73 to 73 in the Electoral College. Even though everyone knew that Jefferson was really at the top of the ticket, Burr tried to game the system and refused to stand aside. Under the Constitution, this threw the process into the U.S. House of Representatives. The resulting House process took place in the lame duck, Federalist-controlled Congress, the one that the voters just voted out of office. It lasted for 6 days and 36 ballots before the House chose Jefferson. In the end, the Federalists, including key party members outside of Congress, like Alexander Hamilton, concluded that Jefferson was the lesser of two evils, and Jefferson was peacefully inaugurated, setting an important precedent for the peaceful transfer of power in early America. Following the election of 1800, we moved quickly to reform the Electoral College. The result? The 12th Amendment. This amendment ironed out some of the most glaring bugs in the original system. With the 12th Amendment, electors in the future would still cast two votes, but one of the two votes would be for president, and the other would be for vice president. The 12th Amendment was proposed by Congress on December 9, 1803, and sent to the states 3 days later for ratification. The amendment was ratified in 1804, and all future elections were carried out under its rules. The Reconstruction era, amendments for the next constitutional amendment, we must fast forward 60 years to the period after the Civil War, known as Reconstruction. Following the Civil War, our nation confronted a series of vexing questions. During this period, we ratified a series of 3 amendments, the 13th, 14th, and 15th, that transformed the Constitution forever. The 13th Amendment, 1865, abolished slavery. The 14th Amendment, 1868, wrote the Declaration of Independence's promise of freedom and equality into the Constitution. The 15th Amendment, 1870, promised to end racial discrimination in voting. It's little wonder that many scholars refer to these transformational amendments as our nation's second founding. The Progressive Era amendments for the next constitutional amendment We must fast forward another 40 years to the Progressive Era, one of the most active eras of constitutional reform in American history. Between 1870 and the ratification of the 15th Amendment, banning racial discrimination in voting, in 1913, the American people didn't amend the Constitution a single time. But between 1913 and 1920, the American people amended the Constitution 4 times. The Progressive Era emerged in the early 1900s. Progressive reformers pursued amendments that unified two key ideas: an expanded role for the government in public life, for example, granting the national government the power to tax income and using the powers of the government to advance the cause of prohibition, and a commitment to institutional reforms, often with a vision of improving American democracy, for example, the direct election of senators and women's suffrage. The 16th Amendment. The 16th Amendment, ratified in 1913, gave Congress the power to pass an income tax. Congress had already passed an income tax during the Civil War. However, the Supreme Court challenged this power in the late 1800s. The 16th Amendment responded to decades of activism and legal action following the Supreme Court's 1895 decision in Pollock v. Farmers, Loan and Trust Company, which curbed Congress' power to pass an income tax. The Pollock decision divided the justices themselves and spurred decades of political activism by populists and progressives to reverse the decision and grant Congress the power to enact an income tax. Finally, in 1913, these reform efforts succeeded with the ratification of the 16th Amendment. So reformers once again used the Article 5 amendment process to reverse a controversial Supreme Court decision. Congress then passed a nationwide income tax in 1913, and we've had one ever since. The 17th Amendment. The 17th Amendment altered an important structural feature of the original Constitution. The original Constitution placed the power to elect U.S. senators in the hands of state legislatures. The 17th Amendment gave this power directly to the voters in each state. Some reformers argued that the 17th Amendment was essential to America's commitment to popular sovereignty and was faithful to our systems, pushed toward a more democratic system over time. Other reformers argued that state legislatures were overrun by parties, machines, and special interests, and that the popular election of senators was a simple way to limit that corrupt influence. For instance, some supporters argued that Senate seats could often be bought and sold in smoke-filled rooms under the original system. Still, other reformers were concerned that state legislative elections were often dominated by who the legislators would select to the U.S. Senate, rather than the candidates' positions on the many important issues facing their states. Finally, some Senate seats remained open for years as state legislatures deadlocked over who to select. The 17th Amendment gives us the system we have today, with voters in each state selecting their senators through a popular vote. The 18th Amendment. The 18th Amendment, the Prohibition Amendment, banned the manufacture, sale, or transportation of intoxicating liquors. The American people ratified this amendment in 1919, and the Prohibition Amendment would eventually become the only example of we the people repealing a previous amendment in its entirety. Our nation's experience with prohibition reminds us that even constitutional reformers sometimes make mistakes, or at least that's what the American people themselves concluded just over a decade after writing prohibition into the Constitution. While it's easy to criticize prohibition in retrospect, it grew out of decades of social movement activism and what many identified as a genuine problem. The problem? Americans drank a lot of alcohol, and this could give rise to all sorts of social problems: wages spent at the saloon, abuse at home, difficulty holding down a job, and so on. And the social movement? A combination of 5, sometimes overlapping groups, consist of the progressives, suffragists, populists, nativists, and white Southerners groups. Some of these reformers were driven by a public-minded concern for the societal problems brought about by excessive drinking, violence, accidental deaths and injuries, unemployment, poverty, parenting issues, abandoning your family, personal illness, and so forth. Some of them were driven by bigotry against certain groups, whether white Southerners against African Americans, Nativist Americans against immigrants like Irish Catholics, or World War I-era Americans against beer-producing and drinking German Americans. Some of them were driven by long-standing political alliances between prohibitionists and suffragists, part principle, part political expediency. This collective movement worked for decades to push for prohibition, culminating in the ratification of the 18th Amendment. The temperance movement itself went all the way back to 1828, so this was a long push for reform, and the 18th Amendment remained a live part of the Constitution for 13 years. But problems soon arose, and many Americans had second thoughts. Before turning to the 19th Amendment, let's complete the Prohibition story and fast forward to 1933 and the 21st Amendment. The 19th Amendment. Finally, the 19th Amendment, ratified in 1920, protected the right to vote free of sex discrimination. Remember, the original Constitution left voting issues largely to the states. But over time, we have added a series of constitutional amendments that extended voting rights protections to new groups. The 19th Amendment is a key part of that story, extending voting rights protections based on sex. With the 19th Amendment, women won the vote. This amendment grew out of decades of advocacy by the suffragists and their allies. Women's suffrage began out west in the late 1800s and eventually spread to the rest of the nation, culminating in the ratification of the 19th Amendment in 1920. So the amendment itself followed decades of widespread experimentation in the states, with many states extending the vote to women before the ratification of the 19th Amendment. Even so, it would take many more years, and the hard work of the civil rights movement to extend voting rights in practice to all women, including women of color. The modern era amendments. In the modern era, the American people added the remaining 8 amendments, little by little, between 1933 and 1992. The 20th Amendment, ratified in 1933, the 20th Amendment reduced the length of time between the most recent set of national elections and when a new Congress and president took office. Prior to the 20th Amendment, a new president and a new Congress took office in the March following the most recent election. The 20th Amendment shifted that start date to January, limiting the length of what's known as the lame duck, in other words, the old president and Congress. And under the old rules, Congress often didn't meet until the following December, so 13 months after the most recent election. The 21st Amendment. The 21st Amendment is the only example in American history of a constitutional amendment repealing another one in its entirety. Here's the key language from Section 1 of the amendment. The 18th Article of Amendment to the Constitution of the United States is hereby repealed. So, pretty direct. The amendment was ratified in 1933. Why did public opinion turn against prohibition so quickly? The simplest answer is that the American people wanted easy access to beer, wine, liquor, and so forth, and they were willing to pay the potential societal costs associated with it. But as our interactive Constitution scholars, Robert George and David Richards, explained it, many Americans concluded that prohibition had been a failed, if noble, experiment. Despite its flaws, prohibition did succeed in lower alcohol consumption in the United States, and with it, some of the societal ills linked to drunkenness and alcohol abuse. However, prohibition also had many failures. It was easy to defy and difficult to enforce. There was a massive black market for alcohol. This spurred the rise of organized crime, and law enforcement did little to stop it. So there was still plenty of illegal alcohol produced and sold. Enter the infamous speakeasy. But it was also linked with crime and violence. Think Al Capone, and the rampant illegality with many Americans consuming illegally produced and sold alcohol made a mockery of the Constitution and the rule of law. This mix of organized crime, police corruption, and consumption of illegally produced and sold alcohol outraged many Americans. The 22nd Amendment, ratified in 1951, the 22nd Amendment limited a president to 2 terms in office. As our nation's first president, George Washington set an important precedent, serving for only 2 terms in office before retiring from public life. This precedent held for 150 years, until Franklin Delano Roosevelt, who was elected 4 times in a row. His final victory was in the 1944 election. Republicans began pushing as early as 1941 for an amendment that restored the Washington precedent, coupled with criticisms of FDR for breaking it. With the 22nd Amendment, the American people looked to reestablish the Washington precedent and write it into the Constitution. The 23rd Amendment, ratified in 1961, the 23rd Amendment granted the District of Columbia 3 electoral votes, adding their voters' voices to the presidential selection process. Prior to the amendment, D.C. residents couldn't vote for president or vice president. With this amendment ratified in 9 months, D.C. voters began to participate in presidential elections. Practically speaking, this had the potential to enfranchise a large African American population in our nation's capital, a move consistent with the goals of the Civil Rights Movement. The 24th Amendment, ratified in 1964, the 24th Amendment banned poll taxes in national elections. It also granted Congress the power to enforce this new amendment through appropriate legislation. White Southerners had long used state laws, like poll taxes, to keep African Americans from voting. These laws were often reinforced by intimidation and violence. When the 24th Amendment was ratified, 5 states still had poll taxes on the books: Mississippi, Texas, Virginia, Arkansas, and Alabama. In addition, the Supreme Court had upheld the constitutionality of these laws as recently as 1937 in Breedlove v. Suttles. The 24th Amendment reversed Breedlove for national elections, and 2 years later, in 1966, the Supreme Court ruled in Harper v. Virginia Board of Elections that all poll taxes in national, state, and local elections were unconstitutional. The 25th Amendment, ratified in 1967, the 25th Amendment covers the issue of presidential succession and incapacity. The 25th Amendment tried to address several issues left open by the original Constitution, and the amendment itself emerged, in part, as a response to renewed concerns about issues of succession and presidential incapacity after JFK's assassination in November 1963. President Truman also pushed for an amendment like this even earlier, back in 1948. Section 1 says that when the president dies, resigns, or is removed from office, the vice president becomes president. So, when President Nixon resigned, his vice president, Gerald Ford, became president under the 25th Amendment. Section 2 sets out the process for filling an open seat for vice president. The president nominates a new vice president, and both the House and the Senate must approve of the pick by majority vote in each house. So, when Vice President Spiro Agnew resigned in 1973, President Nixon selected Gerald Ford as vice president, and the House and Senate confirmed the pick. Section 3 permits the president to temporarily transfer power by a written statement that he is unable to discharge the powers and duties of his office. The president can then resume his responsibility with a second written statement saying that he's ready for duty. So, President Reagan transferred his authority to Vice President Bush for a few hours while he had a planned surgery. Section 4 addresses the situation where a president refuses to transfer his duties when others might conclude that he is unable to fulfill them. It's a pretty complicated process. Today, it requires the vice president and a majority of the president's cabinet to conclude that the president is unable to discharge the powers and duties of his office. The vice president then becomes acting president, but the president can disagree, giving the vice president and the cabinet 4 days to respond. If they side with the president, he resumes his duties as president. If they still conclude that the president is unable to carry out his duties as president, the vice president remains acting president, and Congress must meet quickly and weigh in. The president retakes office unless both houses of Congress vote by a 2/3 majority that the president is unable to carry out his duties. The 26th Amendment. The 26th Amendment was ratified in 1971. This amendment set a national floor for the voting age at 18. Prior to the 26th Amendment, most states still limited voting to those 21 and older. The 26th Amendment was, in part, a response to the Vietnam War. Many young people who were drafted for the war were still unable to vote. In 1970, Congress passed a new Voting Rights Act, which lowered the voting age to 18. But in Oregon v. Mitchell 1970, the Supreme Court ruled that Congress could only lower the voting age for national elections, not state and local elections. To set a national age for those elections, the American people would have to ratify a new constitutional amendment. And so they did. In response to Mitchell, Congress proposed the 26th Amendment. And in March 1971, the states ratified the amendment, less than 4 months after it was initially sent to the states for ratification. This was the shortest ratification process ever. The 27th Amendment. Finally, the 27th Amendment, our final amendment, is a weird one, written by James Madison and taken to the finish line over 200 years later by a passionate student angry about a bad grade on his homework. This amendment prevents members of Congress from raising their own salaries until there has been a new election. So, a pay increase wouldn't take effect until the beginning of the new Congress. Basically, it limits Congress' power to give itself a raise. At the Constitutional Convention, the delegates spent several days discussing congressional pay, but the delegates decided to leave congressional salaries to ordinary laws passed by Congress. This feature of the Constitution came under fire during the ratification debates, and James Madison himself became concerned as well. These critics, echoing arguments advanced by Benjamin Franklin at the Constitutional Convention, feared that members of Congress would choose to pay themselves too much. Enter what would eventually become the 27th Amendment. The 27th Amendment was first written in 1789. That's right, 1789, and proposed as part of the original Bill of Rights. James Madison and the First Congress wrote it and approved it with a 2/3 vote in both houses of Congress. Madison and his colleagues wanted to set some sort of limit on Congress' power to raise congressional salaries. So Madison proposed the eventual 27th Amendment, requiring a new election to take place before a congressional pay increase would take effect. They sent this proposal along to the states for ratification. Within a few years, 6 states voted to ratify it, short of the 3/4 of the states necessary to ratify a new amendment. So, while the American people went on to ratify our current 1st through 10th Amendments, this other proposal did not become part of the Constitution. The states then ignored it for decades. Every now and again, another state would vote to ratify it. But no one thought that the amendment would ever be ratified or even thought about the proposal at all. Let's fast forward to 1982. The proposed amendment looked dead. Very few states had ratified it. Then, Gregory Watson, a sophomore at the University of Texas, was given a homework assignment. He had to write a paper on some sort of government process. While doing his research, he found a chapter in a book that listed amendments that had not been ratified, and he chose to write his paper about the eventual 27th Amendment. His central argument? The proposal had no time limit on it. Article 5 didn't set any deadline either, so the amendment could still be ratified nearly 200 years later. From there, his amendment push gained momentum. Watson's effort went hand in hand with broader public dissatisfaction with Congress in the 1980s. Voters thought that Congress wasn't doing enough to help the American people. They thought that members of Congress were paid too much and enjoyed too many perks while in office. And Watson pushed to build on the ratifications from earlier years to build up to the 3/4 of the states necessary to ratify the amendment. In 1985, 5 more states ratified the amendment. Finally, in 1992, over 2 centuries after the first Congress proposed the amendment to the states, 3/4 of the states, 38 of 50, ratified it. The 27th Amendment became part of the Constitution. It only took a little over 202 years to get it done.